how will the members of the appellate body be paid? To me, there's a paradox. If they are paid by salaries like judges, that means they will earn far less than the lawyers and arbitrators, so they will earn far less. So how can we attract the most competent and capable practitioners from the arbitrators and lawyers to be the members of the appellate body? If they are paid by hours like the arbitrators, then there will be another heavy burden on the parties who appeal. So I think it will limit limit our efforts on setting up an appellate body. Thank you.
Very good question. When you raised that question, it reminded me of some discussion I had many, many years ago when I was still a very young arbitrator. Because I spoke to a very senior and experienced arbitrator, and we were discussing about the pay as an arbitrator as compared to a lawyer. And all of us recognized, as was shown in the figures, the arbitrator gets paid less. But then he immediately reminded me that, of course, when you act as an arbitrator, you are also doing a public service because you are resolving the disputes, albeit of the private parties. So when one is looking at the pay of the judges, I think these judges, if agreed or if appointed to be adjudicators on the appellate mechanism, I think they will see also their role as providing a public service for the international legal order, and therefore probably are, in that sense, not expecting to earn the same had they remain in private practice. But as to whether it should be a salary or an hourly basis, I think there are many models from the international legal system that we can look at. We can look at how ICJ judges are being paid, how the International Criminal Court judges are being paid, and so on. So there's always, that's probably is something that can be looked at. Insofar as the source of funds is concerned, it could depend on which model we adopt, whether it is a multilateral treaty, which involves states, and of course states will have to pay some of the setting up. But I think there will also be an element, given that this is arising from arbitration, possibly something from the parties as well. So it could be a hybrid.
Jan Paulson in the Alexander lecture, I think in 2012, when asked what is the best way to become an arbitrator, remarked, retire as a judge.
Thank you so much for an enlightening presentation. Following up on the concern with being pragmatic and focusing specifically on the selection of the future adjudicators, I think it is important to strike a balance between the necessary guarantees of expertise and this major concern with independence. Because my impression is that if we have some type of revolution or of a more permanent centralized system, there will be some kind of a generation gap. Because we keep talking about a very limited and closely knit epistemic community, but I wonder if we focus too much on breaking the link between some big names in the market and that new system, who is going to be willing or available to decide these cases? Because again, the most experienced people probably will not want to be tenured and without the possibility of double heading. So I would like to also, this major concern with impartiality and independence, I'm not really sure that it will be solved, because in the end all judges and all adjudicators are biased, even if not on purpose, and essentially the problem doesn't have to do with who decides these issues. It has to do with the fact that they are always political in nature, because they involve public interests against private interests. I would like to hear your comments on that.
I'm not sure I can necessarily agree on your last comment about all are biased in one way or another. I think, you know, in all fairness, my experience of working with the arbitrators, I don't seem to see that being a prevailing trend, as it were. There may be some, but, you know. So I understand your point, because it does bring up a very important point about double hatting. And certain people, for example, I was on the exit panel of arbitrators and sat on the ad hoc committee. Some of my colleagues would tell me that they would not sit on the ad hoc committee because they are also appointed as arbitrators in the exit arbitration. So there are different ambit in which one would like to draw that line. It's not exactly an easy question, but then I think, as Anthony was saying, there are retired judges in the international legal system that may serve as a very good pool for this ISDS appellate mechanism. I have to add that I am not saying that it is necessary. I am dealing with the objective reality that it seems that something will have to be done. I tend to believe that we lost the battle because we haven't fought it well enough about the lack of consistencies and so on and so forth. So having faced with this objective reality, I think something will be done, and trying to find a way out is what the first helix is about. So I think it probably will mean that you will need to devise good rules about whether double hatting, in the same way as in the exit panel is allowed, where you can be appointed as arbitrator, but also on the ad hoc committee, and probably, I would guess, if this is to be taken through in any serious way, I think the proponent will probably suggest a separate pool, because one of the concern was exactly the impartiality or independence of the arbitrator. And of course, we all know, I don't have time to go into all the details, is one of the concerns is that of double hatting, not as lawyer and arbitrator. So, now you have as arbitrator and as appellate adjudicator, that same question could arise. So I don't think we necessarily have an answer, but I thank you for that difficult question.
Adrian Lai from Asian Academy of International Law. Thank you very much, Madam Secretary, for the lecture. It's very timely because both the appeal system and the mediation topic are the topics are going to be covered by next session and the session in March in the WG3. And in fact, your lecture has given me some thought on how I'm going to organize my side event next week in Vienna. But I have two questions about this appeal system. You said the preferred system is centralized appellate system. Why do we need a centralized system when the underlying treaty regime, the investment treaty regime, is so decentralized? How ready are states to surrender or to submit their treaty to be interpreted by adjudicators of other states? This is my first question. The second question is about the selection of adjudicators at the appeals panel. How are you going to persuade the investors to accept the appeal system when they have no power, no right to select the adjudicators at the appeal level? Because the beauty of the arbitration is that they have at least some influence over their own appointed arbitrator. But in the appeal system, you're stuck with a pool of, they will say, pro-state adjudicators who will have the final say on their disputes. How are you going to persuade them to accept this idea?
The reason why, again, going back to the problem that we are looking at, and that is the objective reality that people think there is inconsistencies. So assuming that has to be addressed, the only way to address it will have to be centralized, because if you have a number of different courts, different appellate mechanisms around the world, you still have inconsistencies, albeit raised at a higher level, that's all. So therefore, centralized to deal with this perceived inconsistency. As to the pool of adjudicators that I'm putting forward as possibly doable, is different from the MIC, because the MIC is entirely fixated with a much smaller number of people. But if you have a pool of adjudicators, and again, sort of learning from, for example, looking at the exit panel, you can then devise from the very large pool that still come from the states, but usually a larger group of numbers of people, you may then be able to then devise exclusively someone who is doing only the appellate mechanism. So I think that probably is not going to be an absolute resolution, because one of the problems with the MIC is exactly the party appointment. The investors did not have the chance to choose their arbitrators once it is in the MIC situation. So I think that problem can be alleviated, probably not entirely removed.
Can I do a supplementary on that? Are we then going to be driven by the commercial realities that actually if you want to invest, you're going to have to accept that system, and therefore it will come about naturally, and the investor will adjust its bargaining to suit the end result?
That could well be, yes, indeed. I think that could well be. And I think this discussion of how you're going to set up this appellate mechanism to address those mainly two concerns, that of the arbitrator and that of inconsistencies, probably will take a lot more considerations than just a 1-hour lecture.
I hope I haven't stunned you into silence by interposing. No? No more questions. Well, thank you very, very much. A huge amount of food for thought and to take it forward. One other thing I should have mentioned at the beginning, and it is an embarrassment, I'm afraid, for the Chartered Institute, that this was the first lecture, Alexander lecture, delivered by a woman. So I am doubly grateful to you.
And if I may say, thank you very much, Anthony. It's a great honor to be the first woman to deliver the Alexander lecture. I'm sure I won't be the last. There are tons of talented arbitrators and experts who will be able to do that. So thank you very much. And I think that definitely is a revolution, not just evolution.
Thank you very much, ladies and gentlemen. Don't forget, do collect a copy of the lecture as you go out. And Happy New Year. Thank you.
Happy New Year.